Good morning, everyone. Looks like we have about 55 participants on the conference right now, and we're here this morning to have some legal hot topics and COVID-19 form changes discussed by Will Martin. And so I'll give a brief introduction of Will. Will Martin has practiced law for 34 years and is a manager in the law firm of Martin and Guilford, PLLC in Winston-Salem. Will and his partners, Bill Gifford and John Waite, represent real estate brokers and firms across North Carolina on a variety of different legal topics. Will has been general counsel for the North Carolina Realtors for the past 23 years. His duties include advising NCR's leadership and staff on various legal matters, handling a wide variety of inquiries from local associations of realtors and individual members, and working with a number of committees on standard forms, professional standards, and other risk management matters. Will also acts as counsel for a number of local associations of realtors across North Carolina. So it is with great pleasure that I have had the opportunity to work with Will for a number of years on North Carolina residential forms and on the North Carolina Joint Forms Task Force. So please join me in welcoming my colleague and I consider my friend, Will Martin.
Oh, well, thank you, Lewis. Good morning, everybody. It's a pleasure to be with you all. We're all getting used to Zoom meetings. It's kind of nice not to have to drive down to Raleigh to do this live. There's really no substitute, I guess, for a live presentation, but, you know, this seems to be working pretty well from what I can tell. I think it's the way of the future, probably. It's just going to make it easier for us to do these kind of presentations. Before I get started, I wanted to put in a plug for the hotline. That's one of the services that the State Association of Realtors provides that takes up an awful lot of time for John, Bill, and me. We take turns handling the hotline. I've got it this afternoon. Bill has it this morning. Please feel free to use the hotline with your questions. You know, we don't give specific legal advice, but we'll try to get you in the ballpark on what we think the issues are, whatever your situation is, give you some general guidance, and we really love hearing from you. Right now, we're doing it mainly by email because the State Association's offices are closed, so if you call there, you'll get a voicemail, and it'll give you the email address, and you can send us an email. It's a legal hotline at ncrealtors.org, legal hotline at ncrealtors.org. And if you've got a complicated question, you know, just give us your phone number and we'll call you and talk through it. I was asked to run a report yesterday. I want to share with you on how many calls we've had in the last couple of months and how many of those calls have been related to the COVID-19 pandemic. I went back and looked in our membership database, and we created a topic code. We code all these calls and log them in, and we created a COVID-19 topic code, it looks like on March 16th. So I think that's when things were really starting to break loose, and I'm sure we had a few COVID-19 related calls before then, but officially started March 16th. And so I ran a report from March 16th through May 15th, 2 months, and we had a total of 1,100 and something questions on the hotline during that period, of which over 400 were COVID-19 related questions. So we've gotten a lot of questions about COVID-19 related issues, including some of the things I'd like to talk about today. This is mainly it was structured to be an open session so you all can ask questions. I didn't get a lot of questions in advance, but I understand you can submit questions through the chat feature, and Lewis is going to monitor those and read them to me. I'll tell you the same thing. When I get a hotline call, you know, we've gotten pretty accustomed to trying to handle questions on the fly, but if you ask me something that I don't know the answer to or might require a little more research, I'll be happy to do that. I just need to know who to follow up with. with additional information. Maybe Betsy, and can be shared with the whole group, or however you all want to do that. But the one question I did get is about the COVID-19 addendum, and it's a question that we've gotten a fair amount about that addendum. And so I wanted to start out just spending a few minutes talking about the COVID-19 addendum and the questions that we've been getting about that addendum. I wrote a Q&A on this when we released it, which looks like it was March 23rd. And if you'll bear with me, I'm just going to give you, I put a bullet point summary of how the form works, and I thought some of you may not be familiar with how that form works, or could use a refresher on how it's supposed to work. So I'm just gonna read a few of these bullets just to kind of set the table. If circumstances related to the COVID-19 pandemic make it unduly burdensome or impossible for either or both parties to exercise a right or perform an obligation under the contract, there will be a one-time extension of contract deadlines by a number of days agreed to by the parties. A party whose performance is affected by a COVID-19 issue must notify the other party in writing to trigger the extensions. That's an important point that I think some people are missing. Notice may take place in the same way it's typically handled under the delay in settlement / closing paragraph in the contract, so long as it's in writing. The extension of the deadlines will apply to any contract deadline that has not already expired. The parties agree to make a good faith effort to use alternative methods that may be reasonably available to enable them to perform their obligations under the contract. If the parties are unable to close prior to the expiration of the extended period of time and they haven't agreed to another extension, the contract will become null and void. If the contract becomes null and void, the seller will retain the due diligence fee and the earnest money deposit will return to the buyer, regardless of the reason for the delay. And then there's one other aspect of this that's important that I'm not sure we've got any questions about. It's like an additional right. If the buyer is unable to get a loan due to loss of income related to the pandemic, for example, loss of employment, either party may terminate the contract, in which case the seller will retain the due diligence fee and the earnest money deposit will be returned to the buyer. So that's a quick summary of how the form is supposed to work. As far as the questions we've gotten about 3 different kinds of questions. One is that I think people assume that if the COVID-19 addendum becomes part of the contract, that it automatically controls in the event there's any kind of a delay in settlement, and that's not the case. You're operating under the contract, the delay in settlement provision, which everybody's familiar with. It allows up to a 14-day permitted delay if a party is unable to close. The COVID-19 addendum only comes into play if there's a triggering event, and it's very broad. Haven't gotten a lot of questions about whether or not a particular fact pattern is a triggering event or not, but there's got to be an event that makes it impossible or unduly burdensome as a result of the pandemic for a party to perform. That triggers the extension or the application of whatever the deadline extensions are that the parties have agreed to. And there's a blank in paragraph 3 of the addendum where the parties agree, if a triggering event happens, here's how long we're going to delay. We've gotten a few questions about, well, what kind of number should we put in that blank? And of course, that's negotiable. We don't typically give a lot of advice about negotiable terms, but I would say, the addendum is really primarily designed to allow, unanticipated delays the contract, as I said just a minute ago, allows for up to 14 days permitted delay. So it doesn't make a whole lot of sense to me that you would use a number that was, 14 days or less. It would seem to me as though, 15 days, maybe up to 30 days. I don't think I would probably agree to a really lengthy delay. And, the parties, if you get to the end of a delay period, the seller still wants to sell and the buyer wants to buy. They can always agree to another delay if necessary, but, a relatively short delay. So that's one question we've been getting. The question I got from somebody who I guess is probably on the call, it's been probably the most common question is the whatever the agreed upon delay is in the COVID-19 addendum, let's say it's 21 days, is that on top of the 14-day permitted delay in the contract? So you go 14 days and then another 21. The answer to that question is no. If there is a triggering event that causes the COVID-19 addendum to come into play, then that's what controls. It's the terms of the COVID-19 addendum. And it specifically says in paragraph 6 of the COVID-19 addendum that if the buyer and the seller agree that in the event either party gives notice of a COVID-19 related restriction, any delay shall be governed by the provisions of this addendum rather than the delay in settlement/closing provision in the contract. However, if a party is unable to complete settlement by the settlement date due to any non-COVID-19 related restriction, the provisions of the delay in settlement paragraph shall apply. So I think that's pretty clear that it's one or the other, it's not both. And so the answer is no, it's not 14 days then plus however many days the parties agreed on in the COVID-19 addendum. The other question we've gotten, and this is just an example to me of when you put a blank in a form, you're going to get a certain number of people that don't use it properly or have a real misapprehension about what it's supposed to be, what's it for. We've gotten several calls where that blank in paragraph 3 where the parties agree on how many days they're going to agree to delay if a COVID-19 event happens is being left blank. They're not putting anything in the blank. And so they call me and say, well, what does this mean? And my answer is, I don't know, beats me, if the parties leave that blank, what does it mean? I mean, there's several different possibilities. Either one, that they didn't even come to terms, they intended to agree to something, they didn't complete it. It questions whether or not the addendum is really even part of the contract, or gosh, potentially, do they even have a contract? Or if it's interpreted to mean zero, then, if a COVID-19 event, triggering event happens, the parties have effectively agreed that there will be no delay in any dates. And that's kind of opposite of what we were trying to accomplish with that form. So that's just a dumb, in my view, hope I'm not stepping on anybody's toes, putting zero or leaving it blank is just, to me, that's malpractice. You need to put a number of days in there. And as I said, I mean, you can put however many number of days you want, but it doesn't make any sense to me that it would be, fewer than the number of days that are permitted under the contract. So something more than 14. It is important to understand that if the delay in settlement provision in the COVID-19 addendum applies, the parties are essentially agreeing in advance that we're going to take fault off the table, so that if you can't close due to a COVID-19 related issue, the seller's not going to be in breach, the buyer's not going to be in breach. We're just going to agree that the seller's going to keep any due diligence fee and the buyer's going to get their earnest money deposit back. So it is important for the parties to understand that that's the way it works if the addendum applies. So that's all I've got to say about the COVID-19 addendum. If anybody's got any more questions about the addendum, submit a question to Lewis, and I'll be happy to try to answer it. Lewis, do we have any questions at this point?
We just got one, Will. It says, with the changes made to the listing agreement on May 1, those changes are not yet reflected on the offer to purchase. If there is a discrepancy between the listing agreement language and the offer to purchase pertaining to fixtures, is it fair to say that the offer to purchase is what rules, since the buyer was not a party to the listing agreement? I don't have a specific example in mind, but the language relating to smart devices is not yet addressed in the offer to purchase. So it seems there could be a conflict here. And of course, July 1 is coming up quickly. So I'll leave that in your court now, Will.
Yeah, no, I would agree. The contract's going to control ultimately, and what the person who asked the question is talking about is, we rolled out that listing agreement on May 1 to try to be in sort of in keeping with the new clear cooperation policy that NAR mandated had to be implemented by MLSs no later than May 1st. I gather you all did it a little bit earlier than that. So we felt we needed to roll the listing agreement out early. And as you know, the listing agreement includes the fixtures provision and the personal property provision that are actually in the contract. And so we were making changes to that at the same time. So we decided it'd be better to go ahead and incorporate those changes, which are going to be voted on, I think, next Monday. I certainly don't anticipate there's going to be any problem with that, but it'd be better to go ahead and include it in the listing agreement in the May 1 rollout rather than rolling it out May 1 and then rolling it out again on July 1. So that's why we did that. And there is a little bit of discrepancy between the wording, but I don't see it as a big problem. Part of the main reason, I guess, for that change in the fixtures provision is to try to bring to the attention of the parties this issue of smart devices, which are, becoming ubiquitous in homes now, and to get them to think about it. And so I would say if you're entering into a listing agreement now and you go over that fixtures provision with the seller, you need to be finding out what the seller's wishes are with respect to smart devices. And you might have to, since it's not specifically addressed in the offer to purchase that's available now, you may want to, specifically address in the existing contract any, the party's understanding with respect to smart devices. So it's a good question. Thank you for asking that.
And we do not have any additional ones at this point, so
okay,
go ahead and proceed.
Yeah, I'll just move on. Another COVID-related thing, showing guidance during reopening. I've been thinking about that a lot recently, and I will commend to you a document that I found on the NAR website. It's called COVID-19, Showing Guidance During Reopening. It was issued May 13th. If you go to the NAR website at nar.realtor and you click on coronavirus, ultimately you'll get to this document. I think it's under guidance for realtors, and then when you click on that, you'll see this this document. I think it's pretty good. I won't go through all the recommended protocols that are set out in this document, but your firms need to be thinking about these kind of things. I was reviewing a document for a client just yesterday about protocols that are going to be put into place when open houses begin to take place again. And it really got me thinking about the kinds of things that need to happen. And, I think your firms really need to be thinking about the protocols that are going to be put into place. To me, this is just my own personal view, or more than just a personal view, it's my professional view too, I guess, that, I think I would really recommend that people wear masks or some kind of face covering, gloves perhaps, sanitizer, immediately after they've entered the house, cleaning of sanitizing of high touch places, before and after a showing or an open house. One that I've struggled with a lot, and I'm happy to take any questions on it, is this document, most of which I agree with, suggests that before conducting an in-person showing, request both the seller and potential buyers to self-disclose whether they have COVID-19 or exhibit any symptoms. And I'm really torn about this. I'm not sure I agree with that advice. I just think that it could put the brokers in a really awkward position, depending on what they're told. What am I obliged to disclose, if anything, to the other broker? I think that, just from a pure legal standpoint, it's going to be very difficult for somebody to prove, that they caught the virus, when they were in somebody's house, or that they caught the virus as a result of a particular person who was allowed to come into the house. So I think from a standpoint of civil liability, it's going to be very difficult for plaintiffs to try to prove that, they got the virus and were, harmed as a result of that. And there's also a concept of assumption of risk. It's well known now, that this virus is widespread, it's highly contagious, and if you voluntarily allow people to come into your house, you're going to sell your house, you allow showings, or if you voluntarily go into somebody's house, or the grocery store or the hardware store or a convenience store or anywhere, I think you are aware of a known and potential danger, and you're voluntarily submitting yourself to that danger, then you're assuming risk that, you might get hurt or get sick. So I think there's some legal principles that are, would back up, not just sort of jump into the conclusion that you need to start asking buyers and sellers lots of questions. Like, I went to the dentist last week for the first time in a while, and, I got 3 pages of questions on a clipboard, I just don't want to see the industry go there. I don't know what it's going to look like in a post-COVID-19 world, and, we're probably all going to be, maybe permanently much more attuned to the spread of contagious, diseases, and maybe it's going to be standard protocol for, everybody to be asking these kinds of questions. But I'm reluctant for, this industry just to voluntarily go there and perhaps take on a duty that you don't have, and if you start asking these kinds of questions, where does it stop? One of the examples I've given is, if you're a listing agent and you've got that the seller, one of the sellers is pregnant, and we all, know, I think, that it's generally known that, pregnant women probably don't need to be exposed to somebody who's got German measles. That can cause birth defects potentially. I mean, so do you start asking screening prospective buyers to make sure they haven't been exposed to the German measles before you'll allow them to look at a house? I just think that's kind of ridiculous, actually. So I just don't want to see us unnecessarily start taking on the risk of checking on people's health.
Will, you and I had a conversation before we actually started this meeting, and it may be worth bringing up, and that is being a responsible agent when you're showing homes, and if you know that your seller, as a listing agent, has certain requirements in order for that home to be shown, that they be posted perhaps under MLS agent comments or whatever, and a buyer's agent seeing or understanding or reading those comments and requirements as determined by a seller. Ethically speaking, they have an ethical requirement to convey those things to the client. You and I talked about Code of Ethics, Article 3, Standard of Practice 9, which says avoiding providing access to listed property on terms other than those established by the owner or the listing broker. And that obviously could be a violation of the Code of Ethics if the seller's requirements are not followed. And as a buyer's agent, we're not educating our clients as such.
Yeah, I think it's appropriate for sellers to insist on certain protocols. You've got a fair housing issue that maybe I'll touch on in a minute that you need to be sensitive to. But, it's appropriate for a seller to, I think, condition a buyer's right to look at their home on the buyer following certain reasonable protocols, including wearing masks, using sanitizer, gloves, that kind of thing. And if those instructions are, communicated to a buyer agent, and a buyer agent doesn't ensure that those protocols are followed, that's potentially unethical. You cited the Standard of Practice 3-9, that you can't, you can't show the property on, what's it say? You just read it, Lewis. I probably don't need to read it again, but here it is. Realtor shall not provide access to listed property on terms other than those established by the owner or the listing broker. So, you need to be mindful of that as a buyer agent. And it may be that the, how are you going to get caught? The listing agent's not there, the seller's not there typically. But you know what? They may be surveilling you from another location. And if, the seller's requested that buyers wear some kind of face covering and they're surveilling and the buyer's not, I mean, it's a potential ethics violation for the cooperating broker. So,
and we received a comment from Andrew Sims with regard to comments placed in MLS. Andrew says, a reminder to everyone that anything posted in the MLS under agent comments needs to be a direct statement, not a suggestion. It must read PPE is required by seller to view this property. So be definitive about that. If you leave it as a suggestion, that basically says you can or cannot or must not follow it. So
that's a good point. Good point. Another thing I'll throw out there, and this is, I don't know, this is a hard topic. It's probably open up a can of worms, but I'll go ahead and jump in there because it's a question we've gotten a few times, and I'm sure you all will be confronted with this. Is it a material fact that, let's say the seller has been diagnosed with COVID-19 and they're trying to sell their home? Is that a material fact that has to be disclosed? It's a kind of a tough question. There's a statute, and I've got a copy of it here. Hopefully I can put my hand on it, that addresses, oh, here it is right here. let's start out with what I think is a little bit easier, that the house is no longer occupied, but the listing agent is aware that an occupant of the house had been diagnosed with COVID-19. The statute, GS 39-50, is captioned "Death, Illness, or Conviction of Certain Crimes Not a Material Fact." We get questions about this statute quite a bit, but it's almost always in connection with the question of, do I have to disclose the fact that somebody died while they were occupying the property? And so this statute's very helpful in answering that question, because it says, in offering real property for sale, it shall not be deemed a material fact that the real property was occupied previously by a person who died or had a serious illness while occupying the property. And then it goes on, it talks about sex offenders. So if they're not occupying the property, if they occupied the property previously, but they're not currently occupying it, this statute seems to pretty clearly say that's not a material fact that has to be disclosed. You can't give a misleading answer if you're asked a question. So, you know, if you get asked that question by somebody, you have to answer truthfully. I'll share with you, before I do, there's a corresponding statute that relates to rentals. If there are any property managers out there in the audience, it's identical wording, but it relates to properties that are for rent rather than sale. I got two questions back in early April, it looks like, or yeah, early April. I got questions on consecutive days from property managers who were managing multi-unit complexes, and they had become aware that one of the tenants in the complex had been diagnosed as having coronavirus. You know, and their obvious question to me was, what do I do? You know, do I have to tell the other, 29 tenants in this multi-unit complex that this tenant has contracted COVID-19? Very tough question. I reached out to the real estate commission's legal staff to get their view of it, and I got back, I'm looking at an email that I got from Charlie Moody, one of their lawyers. Right. A broker would not be required to disclose that another tenant has tested positive. And the statute the statute I just read doesn't really, or arguably doesn't apply, because it talks about the property being occupied previously. And now we're talking about property that's currently occupied. So does that make a difference? I think perhaps it does. But the commission's view is that that property manager is not under any obligation to disclose. And I'll just read from a sentence from Charlie's email. The presumption at this point really should be that anyone could have it, and you should safeguard accordingly. We wouldn't discipline a broker who chooses to disclose or not disclose, as long as they make no misrepresentations if asked. So, that involved a rental situation. I've reached out to them to ask them if their same analysis would apply to a sale where the owner is currently occupying the property, just to go back to my hypothetical situation. I haven't heard back from them yet, but unless they've changed their thinking, I don't know why the analysis would be any different. So I think there's a good argument to support the proposition that it's not a material fact that you would be required to disclose to prospective buyers.
So, Will, that kind of plays into the next two questions that are very related. Not being considered a material fact. The first question is, how do HIPAA laws play into this situation? And then the second is, when health situation changes from showing time period to under contract period, how does this affect seller allowing or limiting inspections and or buyers attending inspections? And then does this health change need to be disclosed?
Well, regarding the first question, I don't think HIPAA is going to apply to to real estate brokers. Unless you're like involved in the renting or management of medical facilities or something. I could see maybe there would be a way it would come in, but
Would it
I
be
don't
safe?
think.
Would it be safe to assume that if the seller discloses, then they are allowing permission to be used to disclose?
Well, yeah, I mean, if the seller, you might want to have a conversation with your seller. And this is similar advice that I give when somebody calls and asks if you have to disclose the fact that somebody died on the property. You don't have to disclose. You may want to talk with the seller about the possible benefits of disclosing. And in that situation, it's clearly something the buyer's going to find out sooner or later, probably 5 minutes after they move in with their new neighbor. They're going to, their neighbor's going to come over and say, that really was horrible. What happened here last year, that murder-suicide on the property you just bought. They're going to be unhappy when they find that out, and they may try to make trouble for the listing agent or possibly the seller. So, there may be some advantages to disclosing on the front end, something like that, to avoid a problem on the back end. And, maybe that's true here too. You might want to go ahead and disclose, but if it's not required that you disclose, I think it's a conversation with the seller, because, you don't want to unnecessarily stigmatize somebody's property, and have it be known around the neighborhood as the COVID house, it's a tough call, but I think there's some support, legal support, if you don't disclose that, you haven't made some kind of, negligent or fraudulent omission of material fact that you should have disclosed. Now, the second question, Louis, you're going to have to read that one again. I didn't quite understand.
Second question was, when health situation changes from showing time period to under contract period, how does this affect a seller allowing or limiting inspections and or buyers attending inspections? Does this health change need to be disclosed?
Well, so if you don't have to disclose it in the first place, I would say it would make sense that you wouldn't have to disclose it later if you didn't have to disclose it to begin with. So yeah, I don't think that would make any difference to me. Unless again, you could have a conversation with the seller, and if the seller said, yeah, I'd be more comfortable going ahead and letting these people know so they can try to do what they can to protect themselves. But this gets back to the whole, the way to really, if you use protocols that require people to protect themselves by wearing masks and gloves and that sort of thing, and sanitizing high-touch surfaces, that's the best way to ensure that the virus isn't going to be transmitted. And if people focus on that, I think, rather than the legal liability, I think that'll take care of itself pretty much.
And we have another one that came in, and this is referencing Durham, and I think to some degree you've already approached this with a reasonable expectation that this virus exists and potential of someone getting ill also exists, and the buyers and sellers probably are going to realize that that's a possibility. But it says, with Durham's recent showing rules and pending that they do not change to match the other counties or cities around them, can you talk about any liability you see with Durham's rule, wherein essentially realtors, who are the only party authorized to access the property, are not allowed to be in the property with the buyers? We're getting a lot of calls on this.
Well, I don't know if that's a broader than the COVID-19 issue. I mean, the Real Estate Commission certainly has an expectation that buyer agents will accompany their clients to property, won't let them go unattended, And I know that Durham order doesn't allow the buyer agent to go into the property. which I don't understand that, but that's what it says. You can stay outside and communicate with your client by cell phone, but I think I've had a question on that, and my advice was that I don't think the agents are going to get in trouble for following the law, but I really think that the buyer agent needs to confirm the fact that they will not be accompanying the buyer to the property, or at least not, inside the property. And I think it's important for the listing agent to make sure the seller's aware of that and the seller's okay with that. That you're going to have this, are you okay with this buyer coming into the property unattended? If the seller says no, then you don't show the property, I guess. If they say yes, then they're assuming any risks associated with the unaccompanied buyer coming onto the property. But I certainly don't think the buyer agent ought to violate the Durham stay-at-home order, to try to comply with the real estate commission expectation that they accompany the buyer to the property. I'm sure that would take a back seat to the Durham County order.
So, if I'm hearing you correctly, based on the assumption and based on the rules in Durham, you're not advising that there possibly be a release or something that the sellers would sign agreeing for not having an unaccompanied buyer?
Yeah, I don't know. I think if I were the listing agent, if I were the buyer agent, I think I would hope that the listing agent would get something in writing from the seller confirming the fact that they understand that this buyer is going to be viewing the property unaccompanied. I don't think it has to be anything fancy. I think an exchange of emails or just an email from the listing agent to the seller. Ideally you'd have the seller respond and say, yeah, I'm okay with that. That's plenty. I don't think you need a fancy form to obtain the seller's consent and to be able to prove that they consented. It's a good point. It is an important risk management tool to try to have something so that it doesn't turn into a he said, she said thing down at the Real Estate Commission, which we've seen many times.
So a good safe practice.
Yep.
So we have another issue that has popped up for some guidance also. This is relative to the on-site preview addendum. My buyers had a virtual tour of a home, and the listing agent was instructing buyer agents to use 0 due diligence, 3-day due diligence, initial earnest money due at end of due diligence as a substitute for due diligence. Additional earnest money due 15 days later rather than using the addendum.
I'm not sure I followed all that, Lewis. I apologize. They were using the on-site preview addendum, which provides for what do we call it, an on-site preview fee?
Yes. And the listing agent suggested they use 0 due diligence on the contract, the 3-day due diligence date, and then initial earnest money due at end of due diligence as a substitute for the due diligence. It doesn't make sense to me either, but then additional earnest money due 15 days later rather than an addendum. So it sounds like maybe a little manipulation of the intent of the on-site preview addendum.
Well, again, I apologize. I'd probably have to see that in writing before I really understood were they provided for a 3-day due diligence period?
Yeah, that's what this says, yes.
Yeah, maybe it's a 3-day on-site preview period. I don't know. I'm sorry. If the person who poses the question wants to email it to the hotline, I'll be happy to, or Bill will be happy to discuss it with this person.
Okay, thank you.
Any more questions?
Not at this point.
Well, let's see if I've got anything else on my list here.
The agent that sent the question asked a minute ago said they did not use the on-site preview addendum. They just put those terms in the offer purchase.
Oh, okay. Well, just have him or her get in touch with me, and I'll be happy to discuss it with them. Oh, one thing I alluded to it earlier. I can come back to it if nobody else has any questions. It's this possible fair housing issue, and so the concern is that if you're going to prohibit somebody who's been diagnosed with COVID-19 or, exhibiting symptoms of COVID-19 from looking at property, there's the potential that that's a fair housing violation if you can make a reasonable accommodation. I mean, you don't have to give somebody a reasonable accommodation if it's going to put other parties at, sort of undue risk of being hurt, so you don't have to accommodate everybody under the fair housing laws. But, I've seen in the papers that the pandemic seems to be affecting certain populations more than others. The Hispanic community, the Black community, and so there's something called disparate impact discrimination, where although you don't have any discriminatory intent, if the effect of your discrimination, which would be, we're not going to let people with COVID-19 look at the house, if the effect of that has a disparate impact or a disproportionate impact on a protected class, then you can end up with a fair housing law violation, even though there was no intent to discriminate. So that's one concern. And then I'm reading from an NAR. If you go to the NAR site, you'll see a link to this document. I think it's worth reading. There's also a question about whether or not somebody who has COVID-19 is considered disabled. I would think ordinarily not, but according to this Q&A, it says this is a novel question that may ultimately be resolved by a court. Based on information currently available, COVID-19 can have severe symptoms for some people and therefore may ultimately be interpreted as a disability for purposes of fair housing laws. Therefore, while it has not been conclusively determined whether COVID-19 constitutes a disability, it is advisable to treat individuals who had COVID-19 as being covered by federal disability protections. And one other thing in this Q&A that I wanted to read because I thought it was good. What general safety precautions should I take when providing services? Consider implementing safety precautions that protect not only against those persons known to have contracted the virus, but also the many individuals who may be asymptomatic carriers of COVID-19. It's spread a lot by people who don't know they have it. I saw something, I think way back now, I think it was in Japan or China, that 80% of the people who had contracted COVID-19 had gotten it from somebody who didn't know they had it. And so, if you focus only on people that have COVID-19 or have COVID-19 symptoms, you're really probably too narrowly focused, and it's important to implement safety precautions that protect against people who are both symptomatic and asymptomatic. The widespread numbers of persons who may be asymptomatic carriers suggest realtors should take safety precautions in every real estate transaction, regardless of whether any party is known to have or been exposed to COVID-19. If these measures are applied consistently, a realtor can avoid the potential fair housing liability selectively applying mitigation practices to only certain consumers believed to be of greater health and safety threat based on an unlawful purpose. So, you know, I've kind of been harping on this a little bit. I think if you focus on good safety precautions and you apply them consistently to everybody, that's going to help take care of any potential legal liability, whether it's for a violation of the fair housing laws or, you know, just civil liability based on, somebody being injured and claiming that you're responsible for the damages that they've incurred.
So, Will, the mention of fair housing brought up another question. This says, I've had many listings not allow children at showings. Does this violate fair housing familial status?
That's a great question. And now I saw an NAR Q&A on that too. I didn't run across it yesterday when I was preparing for this presentation, but I'm not sure I agree with the NAR lawyer who said that prohibiting children from coming in the house is a possible fair housing violation. Well, I mean, it certainly could potentially be a fair housing violation, but it seems to me that it's reasonable to preclude children from coming into the house. You know, they're known to be perhaps a little more likely to be running around, grabbing stuff, touching stuff. I don't know. I don't see a problem with it. You know, the NAR lawyer said that it might signify a disinclination to sell to a family if you have a protocol that says, look, you know, if you got a family, husband and wife, one or perhaps the husband and the wife, you know, can come in, but we really don't want the kids to come in. I mean, I think you've got a pretty solid sort of a risk management basis for, you know, that sort of a restriction. I just have a hard time seeing that that's going to turn into a fair housing violation, but you know, somebody disagrees with me at the NAR legal staff in Chicago, so you know, that's my 2 cents on it.
Okay. Thank you. Are there any other questions out there for Will? Nothing popping up right now. Other topics, Will, that you'd like to address?
Oh, well, you know, you asked me to, you know, be prepared to, you know, hit the top 10 topics. And so, you know, there are things that we've all heard of here. Let's see if I've got a, you know, just the old reliable ones. You know, does the refrigerator stay or go? You know, that one just never goes away. Which form should a buyer use to terminate before the end of the due diligence period? You know, do you use Form 390 or do you use Form 350? That's a very common question. We recommend 350 just to make sure you clearly communicate before 5 p.m. the buyer's intent to terminate. Assistance animals. Lots of questions about assistance animals. They're all coming up in the context of rental properties to this point. Gosh, the HUD just issued some new guidance on that, which I think is very helpful at the end of January. And if any of you property managers are interested, I wrote an article on it, a multi-question Q&A that went out in a publication that the NC Realtors PMD puts out quarterly. So it's just kind of come out. Some good information in there about whether or not you have to accept documentation that a person is disabled and has the need for an assistance animal that they acquired on the internet. Some pretty good bit of clarification on that issue, which is a fairly common source of questions. Who has to sign the listing of property owned by somebody who recently died? I mean, I had an estate question yesterday. I think I've had at least a couple this week. I don't know if the baby boomers are starting to die off in large numbers and or what, but there's no question that we're getting more questions about how to handle the listing and sale of properties that were owned by a recently deceased person. And that can be pretty tricky. I got a lawyer friend of mine from Charlotte who I know from the Joint Forms Task Force, Rick Poe, to write a pretty good article on that. It was in our magazine not too long ago. And if you're familiar with our website, you know, we archive all the Q&As. Gosh, there's got to be 300 or 400 up there. And under the category of, I think it says Insight Articles, you can click on that and you'll find Rick Poe's article about handling the listing and sale of estate properties. I would commend to you. It's, you know, it's general, but it's got some really good information in it. Let's see. The other one I highlighted here: must a defect that has been repaired be disclosed? The very short answer to that question would be no. You know, if you're reasonably satisfied, you know, and you probably ought to have some documentation to back you up if it ever gets questioned. But if you're reasonably satisfied that the seller has fixed something, then there's no need to disclose something that was fixed. You know, you don't have to disclose a history of the property. You're obligated to disclose material facts that are currently affect the property. So that's a pretty common question. It gets a little more complicated when you're talking about something really significant like a foundation issue. You know, still the general principle applies. If it's fixed, you don't have to disclose it. The question is, can you be reasonably satisfied that a recent, you know, significant foundational issue has in fact been fixed? You know, and so there's probably a little bit of gray area there.
So, Will, regarding estates, would it be safe to say that if you are asked to work with someone on the sale of an estate, to make sure, first of all, if or not a will was involved, and seek the counsel from an estate attorney to proceed properly?
Yes. Yeah, you don't want to just take somebody's word for it. You know, you're approached by somebody who says, "Yeah, you know, my two siblings and I inherited a property, and you know, I'm kind of handling things. You know, I'm the administrator of the estate even." You know, you need to find out if there was a will or not, and you really, I know it's probably a delicate thing. You know, you've got a prospective client there, and you don't want to start, you know, giving them the third degree, but you know, you really need to be pretty sure you know what you're doing and what their authority is. You know, as a general rule, and this is just a very general statement, you know, if you've got 3 kids that inherited property from their dad, and the mom predeceased, so the dad was the survivor, and one of them is qualified to be the executor of the estate, you're probably going to have to get the executor to sign both individually and as the executor, and you're going to have to get the siblings to sign and their spouses if they have spouses. That's probably going to be required on the deed. And, you know, if you back it up, you generally want people to sign the contract who are going to be required to sign the deed. And if you back it up another step, you generally would like to have people who sign the contract to sign the listing agreement. So you need to do some homework on the front end there. And it's for your benefit too, you know, because you don't want to get deep into a transaction. We've had this question, you know, it's on the eve of closing, and the closing attorney finds something. We find that, hey, there's an estranged spouse out there, or there was an heir, you know, that hadn't been included, and it can be a real problem. And you know, if it's something that you as a listing agent, you know, knew or should have known, it could even be a disclosure item, you know, because that's a material fact. Any fact affecting the ability of your principal to complete the transaction is a material fact. and you're expected to disclose those things. And if it requires the signature of some party who nobody knew about until the very end, and you knew about them or should have known about them, then you could potentially be disciplined by the real estate commission for failing to disclose a material fact. So try to get that straight on the front end. And if they died with a will, it's a good idea to have a lawyer look at it to understand the who's going to be required to sign the deed, because in some cases the executor actually can be given the authority, if it's worded right, to handle the transaction without the involvement of other heirs, or devisees we call them under a will. And if they died without a will, sometimes it can be pretty simple, but if they died without a will, the who inherits is controlled by the laws of intestate succession, and it can get complicated in a hurry as to who the heirs are under the laws of intestacy. So it's probably a good idea to, unless you're just absolutely sure, to get some input from a lawyer before you go too far listing and trying to sell an estate property.
It sounds like a good opportunity for that attorney to draw up a power of attorney after everyone has agreed that an individual will be responsible for handling this, and have it worded properly so that they can sell the real property.
Yeah, that's a good point. You can, and it's pretty common for that to be suggested, especially if you have the kids spread out all over the country. It's not a bad idea to, if they can agree, which is not always easy, but if they can agree, then getting one person appointed to kind of handle things is a great idea.
Yeah, we've got one question that says, what's the legal definition of reasonably satisfied? And I'm assuming this is referencing back to your comments about the will being reasonably satisfied, that things are in order as
you think it has to do with my comment about reasonably satisfied that something's been fixed?
Very probably. It's
on
not,
disclosure.
Yeah, not clarified.
Yeah, it's a great question, and reasonable minds can differ, on the answer to that question. There's certainly some gray there, but I would think if you're if you're being asked to list a property where there was some kind of an event, sometimes it's a fire, or the hot water heater starts leaking over the Memorial Day weekend and causes extensive damage. You want to be able to have receipts for the work that's been done, and possibly the opinion of a contractor that this work's been satisfactorily performed and there's no residual damage as a result of whatever the event was, and have that in your back pocket in case the buyer finds out that something happened and it wasn't disclosed to them. You want to have some documentation to back you up that's reasonable under the circumstances.
So in years past, I have heard, and I know others have heard, that certain damages, water damage, having been repaired, does not necessarily have to be disclosed. Fire damage, on the other hand, over the years, people have said has to be disclosed, even though it had been repaired. Can you just address that for a moment?
Yeah, Lewis, I'm not sure I see a distinction there myself. That fire damage, I think, can be repaired just as water damage can. I'm not a contractor. I don't know that there's anything inherent in fire that would make it less, that would lead to more uncertainty about whether or not, repairs had been satisfactorily completed. Maybe there's something in the nature of fire. I mean, I had a fire in my house one time. It lasted about a minute, and we got it put out. But it did cause a lot of smoke damage in the house. I had no idea, I called my adjuster, my insurance agent the next day and said, Bill, should I report this to the insurance company? I mean, you know, it looked like it damaged the sofa in the living room, and, you know, we can see some things it did. He said, oh, yeah, you want to file a claim. And sure enough, I mean, I can't remember what the final number was, but, you know, we had to get somebody in there, and just the smoke, you know, gets into everything, you know, but hey, we fixed it. You know, I can't imagine. I would feel completely confident in not disclosing the fact when I sell my house one day that I had a fire in the house in, you know, 1999. You know, I just don't think that's going to be necessary.
So I know we've got to be cautious of your time because you have another meeting at noon. What would you consider to be your number one hotline call? Would it be that termination notification?
Oh, Lord, that's a good question, Lewis. That's a good question. It would definitely be related to the contract, 2T. It would be some issue related to 2T, but I can't think of one. Yeah, maybe, you know, had a termination issues, you know, questions around the proper way to terminate the contract. That's right up there, if not at the top, for sure.
Okay.
Disputes about, you know, whether or not the one party or the other is entitled to a delay in settlement. That's, unfortunately, that's becoming an increasingly common question, and one I wish, you know, I don't know. I'd like to see us do some work on the delay in settlement provision, but it's very hard, you know, when you get right down to it, trying to tie that down a little bit more. And on balance, it's been a great provision, I think, that we added to the contract a while back now. But, you know, it's got some issues, and I would say, you know, if you're advising your buyer or seller client on the front end, tell them that they should be prepared for a delay in settlement, because it happens a lot. And, you know, you need to manage their expectations. That settlement date, they don't need to get, you know, we're going to try and get it closed by the settlement date, and maybe it's likely that it'll close on the settlement date, but there certainly is a potential that it won't, and you need to plan accordingly.
Super. So do we have any final questions for Will? Again, we have to be conscious of his time, and I'll give everybody else, I'll throw out one more opportunity to provide a question to Will. Don't see any typing going on. So, Will, on behalf of Raleigh Regional Association, I'd like to take an opportunity to thank you for taking time to join us this morning to answer questions. As always, you're very informative, and hopefully we'll help keep someone out of real estate prison, because we don't have to go visit them.
It's my pleasure, Lewis. Thank you all for joining, and again, you know, give us a shout on the legal hotline if you have any questions.
By all means, take advantage of that. It's something that we're paying for in our state dues, and Will and his firm do a great job of answering those questions. Some of those questions are asked often enough that he'll do the legal Q&A over the social media and distribute them through the NCR website when announcements come out from them. So it's really a great service he provides, and Will, thank you again for taking time to be with us. I appreciate it.
Y'all take care. Have a good day.